Good morning. So now from since I have changed the title from students law students tip, now I have titled it as advocate and law students career tips. So again I comments from number one. So a little bit information for you that the assistant public prosecutor post is being called for and you have to be prepared. So little bit tips I will give and go through and try to understand the concept of criminal procedure as well as Indian Penal Code, penal law, then so many things are there to understand what is our system of jurisprudence, criminal jurisprudence, administration of criminal jurisprudence. Now, if you want, in between also I will give some clues in Tamil if those who want to know it. This is Code of Criminal Procedure 1973. See, earlier 1882 Criminal Procedure Code was introduced by colonial ruling. Then 1898 CRPC was there. That prevailed till 1973. Then Code of Criminal Procedure was introduced 1973. Now we have Bharatiya Nagarik Suraksha Sanhita 2023, which was passed on 1/7/2024. So the Criminal Procedure Code is a procedural law providing mechanism for the enforcement of substantial criminal law. In Iqbal Ismail Sodawala vs. State of Maharashtra 1975 3 SCC page 40, they held that the Code of Criminal Procedure spells much difference between rule of law and the rule of whims and caprice. Some chapters deals with substantial law, though the Criminal Procedure Code is a procedure law. Some chapter which deals with preventing offences, then maintenance proceedings, these all are substantial law. Right of maintenance, right of habeas corpus and right of appeal, revision, etc. is substantial law. You do not surprise habeas corpus because 1973 did not contain provision for habeas corpus, but 1898 CRPC contained a provision for habeas corpus wherein there are certain guidelines where you can seek the court to interfere for habeas corpus. Even though the detention order is by a lawful order, but the keeping the detainee in unlawful affecting his human rights, that you can very well approach habeas corpus. All provisions are imperative and mandatory and not directory. The CRPC every provisions are imperative and mandatory and not directory, but still there are exceptions where last 483, 484 CRPC 1973 says which will not affect the trial. CRPC is based upon adversary system of criminal jurisprudence. Accustorial method. What is difference between adversarial system? Adversarial system is respondent superior. You can remain silent. The person who accuses you or files a plaint against you, criminal plaint, it is its duty to prove. That is called adversarial system of jurisprudence. Accustorial system. Here in Western countries, inquisitorial system. Once they file charge sheet, it is your duty to disprove it. Several transformation had taken place in CRPC that we will look into next chapter, because instead of continuously speaking about criminal procedure code and other things. It is far better that I will skip subject one after another, so that you can understand every subject. Uh, and my humble request is, try to perceive and keep store in your mind. If you are not able to keep it in mind, then you do one better thing. Whatever you read, you add, kindly try to write it in your any paper, and after some time you read it again. That will stick to your brain computer system. This is my humble request. Okay, best wishes.